Hello and welcome to the Blackstone Solicitors YouTube channel. If you're a leaseholder, landlord, or just someone interested in property law, then this video is for you. Today we're diving into the topic of deeds of variation, what they are, why you might need one, and how they can impact your leasehold property. So let's start with the basics. A deed of variation is a legal document that allows changes to be made to the terms of an existing lease. Leases are binding agreements, so once they are in place, they cannot simply be altered without formal consent from both parties, typically the freeholder or landlord and the leaseholder or tenant. In essence, it's a way of tweaking the lease to better suit the needs of either party. But why would anyone want to change a lease? Well, there are several reasons. First, extending the lease term. If your lease is running low on years, you may want to extend it to protect your property's value and make it more mortgage-friendly. Second, adjusting ground rent. Some older leases include escalating ground rents, which can make it difficult to sell or mortgage the property. A deed of variation can be used to amend these terms. Third, altering service charge provisions. If the lease doesn't properly account for shared costs, or if it's causing disputes, a variation can help clarify responsibilities. Fourth, permitting subletting or structural changes. Some leases restrict subletting or significant renovations, and a variation may be needed to allow these. And fifth, correcting errors or ambiguities. Mistakes in a lease can cause big headaches. A deed of variation can tidy things up. So how do you actually go about getting a deed of variation? First, both the leaseholder and the freeholder need to agree to the changes. This usually involves negotiations, particularly if financial terms like ground rent are being altered. It's worth noting that a freeholder is under no obligation to agree to a variation, unless there is a statutory or contractual requirement. Once an agreement is reached, a solicitor, like us at Blackstone Solicitors, will draft the deed of variation. This legal document will then need to be signed by all parties, executed as a deed, and in some cases registered with the land registry. Naturally, you might be wondering about the costs. The expense of a deed of variation will vary depending on the complexity of the changes and whether additional negotiations are needed. Typically, costs may include legal fees for both the leaseholder and freeholder, land registry fees if registration is required, and any premium payable to the freeholder, especially if the variation benefits the leaseholder financially. As for timing, it can take anywhere from a few weeks to several months, depending on how smoothly negotiations go and whether the freeholder is cooperative. So, there you have it. A deed of variation can be a crucial tool for making necessary adjustments to a lease, but the process can be complex. That's where expert legal advice comes in. Here at Blackstone Solicitors, we have extensive experience in leasehold matters and can guide you through the entire process, ensuring that your rights and interests are protected. If you're considering a deed of variation, don't hesitate to get in touch with us. You can find our contact details in the description below. And if you found this video helpful, please like, subscribe, and hit the notification bell so you don't miss out on our future legal insights. Thanks for watching, and see you in the next video.